Welcome, Brad Snyder, to Democracy Nerd. I am Jeff Smith. We have known each other in some measure for a long time, and that's probably worth touching base as well. It is June, and by that I don't just mean dads and grads. I don't just mean sports, even though we are right now recording in the thick of the NBA Finals. And to any Boston sports fan listening, I'm not that sorry that you're not in the in the NBA Finals. It actually, I was told to say sorry. I'm like, I can't do it. We got to be honest some of the time. But it does mean it's Supreme Court decision time. The last chance that we spoke, we got a little bit into this previously in these series of interviews. We had Michael Waldman, the head of the Brennan Center, on his new book about the new decisions released in June of last year. And in this past month, the court has already ruled that the Environmental Protection Agency can't actually protect the environment vis-a-vis wetlands, or at least is severely limited its abilities to do that. So we thought we might get into that a little bit, but it's at least a not welcome. It is an almost lazy reminder, or at best an important reminder of what we're here to talk about. We're joined by Brad Snyder, law professor at Georgetown University, author of the recent book, Democratic Justice, Felix Frankfurter, the Supreme Court, and the Making of Liberal Establishment. Hello, Brad, and welcome to Democracy Nerd.
Jeff, I am so psyched to be here and talk with you about the Supreme Court, particularly on this day, where it's like a rare day where I'm actually surprisingly happy about a Supreme Court decision, where the Supreme Court today has struck down an Alabama redistricting plan as basically diluting the votes of minority voters 5-4. And it just, for so long, the Supreme Court has played this kind of anti-democratic role in our society. And that's really what my book's about. It's about a guy named Felix Frankfurter, a justice on the Supreme Court, who was supposed to be this liberal savior when he was appointed by Franklin Roosevelt in 1939. And his colleagues on the Warren Court thought that he was this liberal lawyer who turned into a conservative justice. My book says that's not true at all. What Frankfurter understood was that the Supreme Court is an inherently conservative institution, and that we should not rely on the Supreme Court to solve all of our problems. We should rely on things like the Voting Rights Act and the Civil Rights Act of 1964. And, his faith was in Congress and the president and not the court. And I think Frankfurter, by many measures, has been vindicated, right? He told his liberal colleagues, we're not going to have a majority forever. And there hasn't been a liberal majority on the Supreme Court of the United States since Earl Warren retired in 1969, before you or I were born, right? So, I think Frankfurter's prophecies come true. And his protege, Alexander Bickel, a famous law professor at Yale, said that judicial review is anti-democratic and a deviant institution in American democracy, and by large measure that's true, right? And that's truer today than it's been almost ever. So today is kind of the anomaly day, or the weird upside down day, where the Supreme Court actually does something to promote democracy, right? And plays a democracy enhancing role rather than an anti-democratic one. But it's basically the exception that sort of proves the rule. The fact that the New York Times is going crazy over today's decision, this is what the Supreme Court should be doing, but it doesn't.
So let's talk about the decision that just came out, and then I want to get into the idea of the Supreme Court as a conservative institution, and I mean sort of small c conservative institution, and as well as now in modern times a capital C conservative institution. But walk people through, or give people the update on what just happened.
Yeah, I mean, I haven't read the whole decision. I've just read the media accounts, I have to say, and basically what happened was a court ruled, a lower court of 3 judges ruled that Alabama's Black citizens had all been basically cracked and packed, which in voting rights terms means they'd all been kind of shoved into one district, right? One congressional district, to dilute their power in the state, and that at the very least there should be one other district that is majority Black, so they can be represented in the United States Congress, rather than all sort of cracked and then packed into a single district, where it's really diluting their representation in Congress, right? And gerrymandering is a problem for both political parties, but racial gerrymandering is something that's been going on since Felix Frankfurter has been on the court. And the Supreme Court ruled 5-4 with Brett Kavanaugh and John Roberts joining the 3 liberal justices that this was basically a racial gerrymander, and that they have to go back to the drawing board and create. And I think to create a second Black majority district, it was measured, right? Because Kavanaugh and Roberts were measured, but it was not a win for the Alabama redistricting plan that put all the Black residents in one kind of majority Black district. It was a loss for those folks, and it was a win for Black voters in Alabama. And they did not do any damage to the Voting Rights Act, and people feared that they would do some damage to the Voting Rights Act, and they did not. So that's today's decision. I think the bigger question, Jeff, is why is the court a small c conservative institution, as you put it? I think it's always been backward looking and not forward looking. You know, from your law school experience and your experience clerking on the Ninth Circuit, that the courts rely on precedent, courts rely on history, courts rely on tradition. Just the mere fact that most Supreme Court decisions are based on precedent, past decisions, that means they're going to be backward looking and not forward looking. And judges tend to be older, right? Those judges tend to have a different set of worldviews than sort of a median voter might have. And so, I think for those reasons, courts tend to be small c conservative, and Frankfurter knew that based on his own life experiences in the political arena.
And I want to, 2 other factors occur to me, and one of them I might even be stealing from you, but the first one is, it overlaps with your statement where they're older. It's not just they're older in age. Joe Biden is older, but their time of political accountability, their time when their politics were even part of the analysis of their selection, is itself a lagging indicator. Like you can think of Supreme Court justices as a lagging indicator of the politics that were happening at the moment that they were appointed, or the election that happened most recently prior to when they were nominated. And that's not always a perfect guess, right? Earl Warren ended up having different politics than maybe were predicted by his appointing authority. And that's been true of Justice Souter and a bunch of other justices. But nonetheless, you have this sort of lagging indicator piece. And the other piece is that when, and I'm trying to think, was this Waldman? I think this might have been Waldman. When the Supreme Court ends up wielding significant power, when they end up really diverting from both precedent and or public opinion and or sort of the arc of the moral universe, it has seemed to, in important times, yielded significant voter backlash. And I don't mean like people are grumpy and like write mean letters. I mean that it can build movements that end up trying to turn the tide of the entirety of American politics. And everybody in this phone call would be in favor of Brown versus Board of Education. And we know that helped birth even the fundamentalist homeschooling movement, right? Helped birth that much of the right-wing economic movement that was shaded in economics, but was not very well disguised racism even then. That Roe versus Wade, nobody on this call would wish that opinion hadn't been decided. And we know that at the dawn of that opinion was at the announcement of that opinion was the dawn of much of what we see as the conservative right wing right now. And if you go back, Plessy versus Ferguson also had its own backlash. So that's the other piece. Is it about who the justices are, right? Is it this idea that they're lagging indicators, or is it also something about the American people aren't ready for, typically, and I don't mean like right now at this moment, I mean kind of ever, that human beings generally aren't that excited about an unelected board making monstrous decisions that are significantly out of step with where voters might be, or even if not significantly out of step, are hugely significant decisions and might be a little bit out of step.
Those are all great points. Let me just take a couple of them, right? And then we can keep unpacking them because there's so much in there. The lagging indicator point is great, whether it's yours or Michael Waldman's.
No, that
right?
one's definitely mine. The second one might be his.
Sam Alito wrote, the opinion in Dobbs overturning Roe versus Wade, but he was appointed by George W. Bush, right, 3 presidents ago. He is the lagging indicator. And, we know how controversial after, we graduated from law school, the 2000 election was that got Bush in there in the first instance, right? Of course, he got reelected and then Alito got nominated, but still, there's the lagging indicator right there. And the response to Alex Bickel that the court is counter-majoritarian is that, well, the court usually follows public opinion, right? Barry Friedman wrote that book called The Will of the People, but that's no longer true, right? The court is way out of step with public opinion, but I think the Republican Party likes it that way, right? Because the Republican Party is out of step with public opinion, right? The Republican Party has become a minority party, but the Democrats have their own issues. The Democrats, for a long time, their strategy was, what does Justice Kennedy think, right? And so when they had a problem, they say, oh, well, how can we convince Anthony Kennedy, who was, the median, that swing voter on the court during the early Roberts court? Well, that's not a strategy, that's a tactic, right? It's not even a constitutional theory. And as I kept telling my law students, that's a bad tactic, right? And while the right's building up these theories about textualism and originalism, the Democrats are saying, well, how do we convince Justice Kennedy? Well, that's an evanescent, tactic. That's not going to work long term. And so now Justice Kennedy isn't the swing voter on the court. It's Brett Kavanaugh, and it's really Kavanaugh's court, right? Kavanaugh, what Kavanaugh says really goes now. And the question is, Democrats need to rethink their entire constitutional strategy. And if you'll indulge me, I'll tell you what I've been telling my classes I think that strategy should be, right?
Please.
Which is
so I want to pause right here.
Yeah.
Because just to make sure that everybody sort of, because this is a big deal. It sounds to me, I'm very interested in this part. We don't have fanfare. I can give an air horn. We don't have, but figuring out what a sensible, use your term, a democratic court strategy ought to be. That's fascinating. All right. That's my version of mumbled fanfare. All right, go ahead.
So I just think the left buys into this idea that the Supreme Court has the last word on the Constitution. Okay, it buys into that idea from a myth about a case from 1803 by John Marshall called Marbury versus Madison that didn't say that, right? The case doesn't say that, but the Warren Court bought into that idea. Justice Brennan endorsed that idea, and really most prominently in Baker versus Carr in 1962, when he called the Supreme Court, quote, the ultimate constitutional interpreter. The Supreme Court does not have the last word on the Constitution. They are not the ultimate constitutional interpreter. All 3 branches have co-equal roles in interpreting the Constitution. And what the Democrats should be doing is turning to those co-equal branches and encouraging our elected officials to assert their roles as constitutional interpreters in a large varieties of ways, whether it's executive orders, whether it's legislation, but pushing back on the Supreme Court's interpretations of the Constitution, particularly when it comes to the 14th Amendment. Justice Kennedy, that hero of liberals, he eviscerated Congress's role in enforcing the 14th Amendment in a case called City of Burney versus Flores in the late 90s. But the 14th Amendment, in Section 5 of the 14th Amendment, Congress has a textual right to enforce the 14th Amendment. It just hasn't used it, Jeff. And these other branches, Congress and the president, need to play their co-equal roles in the 14th in enforcing the 14th Amendment, just as Lyndon Johnson did, just as that Congress did with Everett Dirksen did, right? Just as our past elected officials have, and not waited for the Supreme Court to solve all of our constitutional problems in the way that we would like.
All right. Give some examples of how a president or how a Congress would reassert their role in interpreting the Constitution, and as distinct from merely disregarding it or disregarding the Supreme Court's view, even though they might disregard the Supreme Court's view. What might that look like? Give some examples.
I'll give you an example. I mean, I think the text is on the side of liberals. Okay, the text of the 14th Amendment is on the side of liberals. An example would be a national abortion rights law that Congress passes, not under its power to regulate interstate commerce, but its power to enforce the 14th Amendment. And that would say, look, we are making an interpretation as co-equal constitutional interpreters that we believe that there is a right for women to choose whether or not to have a child. And so we're going to use our powers under Section 5 of the 14th Amendment to pass such a law. So that would be one.
Okay,
right?
so let's stick with it. Let's stick with that. So let's say they do that, and that means there's language, sort of language in the legislation that they pass that sort of says, hey, any court reviewing this, understand that we are interpreting the Constitution here, and we're just as powerful as you. And we think that impacts what a court says. Or then if the court disagrees with that, we'd say, well, we're doing it anyway, and we're asking the executive branch, we're asking states to continue to follow or ask I guess it would be asking the executive branch, asking the enforcement arm to enforce the law, even though the Supreme Court says otherwise. Keep taking that steps down about how that.
No, I'll keep taking it down the road. Let's say they pass my abortion rights law, right? That after, up to the third trimester, any woman in the country has a right to an abortion. And after that, the states can regulate it, right? Approximately the way that Roe versus Wade, or at least Planned Parenthood versus Casey, laid it out. Let's say the court strikes that new law down, Jeff. Well, then the next move by Congress and the president could be, we're going to take away the Supreme Court's appellate jurisdiction to hear any cases involving abortion rights. Congress has the power to decide which cases the Supreme Court of the United States hears. It's done it in the past. In the Bush administration, they tried to take away the Supreme Court's right to hear cases involving detainees, right? It can be done, right? So so that's a way of signaling to the Supreme Court, hey, we don't like the way you're interpreting abortion rights, so we're going to take away that right, and we're going to lodge it in instead the DC Circuit as the court of last resort, instead of you guys. That's what happened in the detainee cases, and I think the left is perfectly capable of that, and saying, we don't like your constitutional interpretation, and particularly as it comes to Section 5 of the 14th Amendment, where the text says we have a co-equal role in enforcing it.
So let's say that's let's go back a step, and and now we are imagining we're imagining this world where Congress is more majoritarian than the Supreme Court. And I think at this moment it's hard to say otherwise. If we think about the most small d democratic institutions, how would you rank them? I think you'd rank them number one, the state house, number two, the U.S. House, number two, the U.S. Senate, number three, the Supreme Court. If I'm wrong about my ranking, tell me. But if I have it right, then make the case for why you'd say that the U.S. Senate that gives, 28 Senate seats for states that amount to, fewer voters than the state of Texas or Florida, not to say nothing of California, that we in fact have a majoritarian path relying on Congress.
Well, you're totally right. This is Sandy Levinson of the University of Texas's point that we have an undemocratic constitution, that the Senate, by apportioning 2 senators per state, is inherently undemocratic. But I just think if Democrats run on this issue of abortion rights, that's a winner, right? Yeah. That even with the deck stacked against, right, the majority in the Senate, I'm with your rankings. I don't know where I would put the presidency because of the Electoral College, right? I think I'd put the presidency maybe behind the House, but in front of the Senate in terms of being majoritarian. But still, even with the Electoral College, even with gerrymandering in the House, even with 2 senators per state that gives the population of New York State the same amount of senators as, say, the people of Wyoming, right? Which is completely crazy, right? But even with all those problems that are inherent in our system, when the president and the Congress fail to exercise their 14th Amendment powers, right? It's like when muscles that become atrophied, Jeff, and this has been going on for a really long time. I'm not just going to blame it all on William Brennan, right? When the Congress, and these guys are heroes, when they passed the Civil Rights Act of 1964, the Kennedy Justice Department made a huge mistake. They said, we're going to pass this under the Commerce Clause because we know we can get a 9-0 decision if we pass this law under the Commerce Clause. And a great constitutional law professor at Stanford named Gerald Gunther says, you guys are screwing up here. This is not about commerce or regulating interstate commerce. This is about discrimination. You should be using Congress's power under the 14th Amendment. And they didn't, because they were worried about overruling some 19th century racist Supreme Court decisions around the time of Plessy versus Ferguson that maybe stood in their way a little bit, or they were worried about not getting an unanimous court. And I think what's happened is the Congress, because they've so frequently exercised their 14th Amendment powers, those are like atrophied muscles, and Congress has to build those muscles back up again by using them and by trying to pass legislation under Section 5 of the 14th Amendment to protect our rights as equal citizens.
When you said you were going to go, you wanted to suggest or recommend the Democratic, big D. I'm going to focus a lot on the capitalization of the first word, on big D Democratic strategy for approaching the court. I thought I might also hear, or might instead hear, one of two things. And I still want to understand better the thing that you said, sort of this idea of how other branches of government can assert and Daniel Webster, right, used to argue about the Constitution, right? There used to be conversations in Congress about how to interpret the Constitution. It wasn't like, oh, let's hand that over to legislative council and they'll tell us if it's constitutional or not. They thought that part of their duty as elected representatives was in fact to interpret the Constitution and to manifest that into law. I thought I was going to hear, so I do want to get more into that. But I thought I was going to hear two other things, or I thought there's a chance we might hear two other things, or at least we hear a lot, two other things. One, win the presidency, win the U.S. Senate, prioritize more highly the courts. That since Brown versus Board of Education and since Roe versus Wade, I would say most meager. I would say the most, even the most venal, the certainly the most racist and the most sexist elements of our political power in our country have built power and trained their voters to care deeply about the composition of the court. So even if they don't love who the president is, even if they have, and that enables them to give standing ovations to Donald Trump as evangelical Christians in full view of how this person has lived his life, what his worldview appears to be, what his sense of morality would be defined by, even them. And they say, hey, he got us justices. So that's great. So they've trained their voters that way. Meanwhile, the outside, maybe Georgetown Law School, the number of Democratic voters who would list the Supreme Court as one of the 2 or 3 most important reasons they would cast their ballot, it's a much smaller number. So I thought I might have heard that as a strategy. Second thing that we hear a lot about is some version of term limits on justices, or increasing, going from 9 to 12 or 9 to 13 or 9 to some other number. And with the argument that's not court packing, the court's already been packed. All we're trying to do is make it more democratic. Where do you think, and maybe there's others that I'm missing, where do you think those lie in a strategy of, it's sort of a democratic strategy around the Supreme Court? Like, also important, not as important, overstated, flatly wrong? Say something.
Yeah, so those are great. So I want to take all of them. First of all, I think the Democratic Party's ideas appeal to the majority of the American people. Like, I feel like abortion rights is a winning issue for the Democratic Party long term, right? And I feel like equal citizenship for LGBTQ people and equal citizenship for all of us, regardless of race and color, are winning issues long term. So I'd rather run on the issues than run against the court, right? But that's to say that has been effective in the past. I'll give you 2 presidents where that's been real effective. Theodore Roosevelt, when he made his third party run for the presidency, he ran against the court in 1912. right, as anti-labor and pro-business. But more, and he almost won. More effective was FDR, right? In 36, right? FDR really ran against the Supreme Court of the United States that was striking down all of his New Deal programs. And, he won in a landslide in 36, right? He said he challenged the Supreme Court's horse and buggy view of the Constitution, right? Those are his words, and then won in a landslide. So I think it's possible, right, to run on the court, but I think you're right, Jeff, that Republican voters just care more about the court institutionally. I think they have more faith in that institution than the Democratic institutions who do their bidding, in part because their ideas have no traction in majoritarian politics, right? So they see the court as
recently.
their only outlet, right? As far as increasing the size of the court goes,
let's stick with what you just said for a moment. So
yeah.
First of all, agreement, like the George Will, before, I think it was before the Kavanaugh appointment, it was 5, 6, 7 years ago, did an interview where he was explicitly calling for, and I think his book actually said it, I just didn't read his book, explicitly calling for essentially renewal of a Lochner era in the federal court system, right? It's basically making your point that we don't trust majoritarian institutions. We think that the will of the people will do things like pass overweening environmental protections, pass overweening middle class protections. We need a set of mostly dudes in robes saying, no, we're going to limit people's rights and we're going to limit the power of democratic institutions. So yes to that. I don't go though so far as to say, therefore, let's not focus on the court. But even though I agree with everything I heard you say, because I'd put it this way, I think one of the advantages of not running against the court, but working to train one's movement, build it as a precept of the movement. Training sounds too paternalistic, but because so much of this comes from the bottom up and the middle out. But infusing within the movement a prioritization of the federal court system is that then the issues are always on the ballot, right? You go to a given congressional seat, and maybe even, heck, Joe Manchin, right? Hard to say that hard as environmental activists to go out there and, champion Joe Manchin's reelection to the U.S. Senate, right? Hard to do that on any number of issues that as a Democratic voter. Flip it for your favorite Republican favorite Republican senator, somebody they're not that excited about, either based on their personal life, based on their voting record, whatever, just not that excited about. Nonetheless, they have a clarion call and their issues are always on the ballot. I don't mean the court being that issue, but I mean it gives them their chance to talk about abortion. It gives them their chance to talk about limiting gay rights. It gives them their chance to, if you're George Will, to talk about, hey, well, let's make sure that they don't do what an FDR administration would do, or at least we block them when they try because we've got the courts in our pocket. So winning on issues long term. So I guess those would be quick responses. Feel free to push back or add to that.
Yeah, I think it's an and not an or, right? Yeah. I would run on the issues and run against the court. I do want to say about the Biden administration, it has prioritized judges better than the Obama administration did in terms of quantity, right? I mean, you could take issue with quality or who they're nominating, but certainly, so I think they're really prioritizing quantity. They're also really prioritizing diversity, right? Where you had a Trump administration that was predominantly appointing white men to the bench. And then you have the Biden administration really trying to fill as many vacancies as possible, while they have the majority in the Senate. So I do think that in that instance, the Biden administration is prioritizing the courts and is trying to signal to Democratic voters that the courts are important and that I think that's one of the reasons to reelect Joe Biden. He did a great job on the court. The irony is that he did a better job on the court, better than a Harvard law educated former con law professor from the University of Chicago who had other priorities. And look, I can't fault Obama's priorities. The Affordable Care Act was the most redistributive piece of legislation, since the Great Society. So Obama ran on that and he did it, and I give him full credit, but he didn't feel like he could do that. And prioritize the
Well, maybe
courts.
you asked my question, which is why do you think do you think Biden's advances there were because of some of in his heart different priorities, or his team realizing its greater importance given what's happened with the Dobbs decision, et cetera, or was it in fact because he didn't have as friendly a Congress and therefore that was a place that they could go? They weren't going to pass the next version of the Affordable Care Act.
I think the Democrats have realized we need to play hardball on the courts too, and I think
Yeah.
there are a lot of smart people in the Biden administration that says we need to nominate as many people as we can, as quickly as we can, and get them through the pipeline before we lose the Senate, right? So I
Yeah.
think they learn that lesson. I hope they learn it long term. But the second part you asked me, Jeff, was as interesting as the first, which was about the idea of either court packing or term limits, and I'm more in favor of the latter. I'm more of a term limit person.
Yeah.
I think limiting all federal judges prospectively to 18 or 20-year terms would depoliticize the federal judiciary somewhat and would lower the temperature on nomination hearings, particularly at the Supreme Court level, but even across the board, because they would become more regular. And I think Congress doesn't need a constitutional amendment to do that. The Constitution says that judges can sit for good behavior. It doesn't say life tenure, it says good behavior. And I think it's up to Congress to define what good behavior. Define good behavior
means 18 years.
Good behavior means 18 to 20 years, and good behavior also means and abide by this code of ethics for those 18 years as well. Yeah. Right. So I think the ball's in Congress's court on this, Jeff, about defining good behavior. This is what I mean about Congress's co-equal role as a constitutional interpreter. Right. So I think term limits would be a good thing. I'm going to make a bipartisan point here. Justices on the Supreme Court are staying on the court too long. Right. Ruth Bader Ginsburg stayed on the court until she died. Chief Justice Rehnquist stayed on the court until he died of throat cancer, right? We don't want justices doing that, right? The game now, Jeff, is to appoint justices who are in their 40s to the Supreme Court of the United States, where they have no real life experiences outside of sitting on a court of appeals for a couple of years before they get on the court. I think that's really bad. I think some of our best justices had a lot of really rich life experiences in other branches of government and in state government, and can bring that to the bench, on the Supreme Court. So I think term limits would do all of those things, and it would prevent these nomination hearings for justices from becoming circuses and kind of these zero-sum game affairs if we knew that there was going to be more frequent turnover on the bench.
So let's stick with that then. Let's stick with the term limits idea for a moment. I heard another proposal, another term limit proposal, which is essentially what I'm sure you've heard of too, which essentially you still have lifetime appointed federal judges, but they rotate, right? You only get to be on the and their argument was, so their textual argument was, it's Article 3, it's the judges, both the Supreme Court and the inferior courts, shall hold their offices during good behavior and shall at stated times receive for their service compensation, which shall not be diminished during their continuance in office. And just to define office as being a federal judge, and you get to sit as the Supreme Court judge for 18 years or 2 years or a 6-month panel or whatever it is. Counter arguments could be maybe that's no easier, right? Maybe it actually isn't more politically doable. A second counter argument could be, yeah, but it still politicizes the entirety of the federal court, right? If you know what you're doing is creating a jury pool that's going to be selected, you're going to care about every single one of those people who could end up being one of those 9 or those whatever number. But is that a proposal you've considered, and are there reasons you like it less?
I've heard that. I like that idea. I think it's good. I think you could say every judge is a senior judge after 18 years, right? And so therefore, if you're a senior Supreme Court justice, that means you're welcome to sit on the lower courts of appeals or at the trial court level if you want. But your time sitting on the Supreme Court of the United States is over after 18 years. I'm okay with proposals along those lines. That would be good by me. I'm certainly not trying to, take away their salaries in any way, shape, or form, right? So I wouldn't want to go there. But we've had senior judges or retired Supreme Court justices who've sat on courts of appeals. David Souter did for a while. I'm not. That wouldn't bother me. The rotation idea wouldn't bother me at all, right? So I just think we don't need any more non-hearings like Merrick Garland's, or we don't need these kind of blood sport events over Supreme Court nominees. I just don't think what happened during the Kavanaugh hearings was good all the way around, right? Regardless of how you feel about Kavanaugh as a nominee, like that was not good for American politics.
And obviously no disagreement, to your preference over term limits, over composition, over court expansion, right? It sounded to me like that was more than just preference. It sounded like it was you liked another one less. You liked the idea of court expansion less. And how come? A moment ago you said, and I don't know that I even have an axe to grind, to be clear. But a moment ago you said, well, I think there are now people within the Democratic power structure who are now prioritizing the court more, and the word you use are willing to play hardball. And some would say, well, yeah, FDR was willing to play hardball when he realized there was a Supreme Court that was abrogating the will of the people, and certainly his administration over and over and over again. You say, all right, I'm going to play hardball with the court. And maybe it's not a matter of hardball or softball, but what are your concerns about a push from 9 to 11, 9 to 12, 9 to 13, 9 to 102?
Well, actually getting votes for it, I think people are going to be unwilling to get the votes for that. Yeah, I also think that 9 kind of works right at the Supreme Court. I think it's been there I think it's what Akhil Amar at Yale would call one of those unwritten constitutional rules, right? We've had it since shortly after the Civil War. And that's how the Supreme Court's kind of operated with 9 justices. I just think the number, just like a 7-game series in basketball kind of works, Jeff, like 9 on the Supreme Court kind of works. And I just think they're more equally effective and like more palatable ways of playing hardball. And that's where I think like jurisdiction stripping is hardball, right? And it's just as kind of an extreme kind of measure. Term limiting federal judges, or at least making them go senior, right? Is a kind of hardball, and I think it's more palatable to the kind of voters, and it's more, and I think it would be easier for Democrats in the House or the Senate to vote for something like jurisdiction stripping or term limits on judges than it would be to increase the size of the court. I just think that's kind of that's a tough. Nobody's ever really done that since an unelected president, Andrew Johnson, right? What was the president of the United States, right? So that's a tough lift, right?
Well, I'll give you another. Go ahead. I mean to cut you off. 39th Congress.
No, you're good. I just think it's a tough lift, and I also think it kind of works, right, with 9. And I'm not sure. I just don't think it's going to happen.
I'll give you another. When you talked about the problems of the current Supreme Court, when anybody talks about it, nobody really actually says the problem is that it's too small, right? They say the problem is a lagging indicator. The problem is it's too captured. The problem is it's too influenced by a president who might not have won an actual majority of voters to get electoral college and approved by a number of senators who didn't reflect the majority of the country. Like the essence of it is a Supreme Court that is out of touch and is wielding power in bad ways. Not really about its size. And if you then have a solution, which really kind of what you're doing is saying, well, this would give us our chance to appoint a few more and therefore have a temporary balancing. That's not a permanent balancing. It would then just be more justices would be a problem in the future, right? Or like more slots that suffer from the same dynamics.
That's totally right. You said it better than I could. I also think as Democrats, capital D, we've outsourced our democracy to the Supreme Court of the United States, right? This is the Justice Kennedy idea, right? When we thought DOMA was wrong, we didn't ask Obama to repeal DOMA, the Defense of Marriage Act, right? We ran to the courts and we ran to Justice Kennedy to get him to strike it down, and he did. And some of that's our Democrats' own fault. I know Democrats hate when I say that, and my students on the left hate when I say that, but it's true. right? We thought, oh, we've got 5. Let's just go solve all of our problems that way, right? Well, I think there are other ways to solve the problem. We've got 2 other co-equal branches of government that are co-equal to constitutional interpreters. Let's use them rather than pack the court from 9 to 12.
All right. I want to get back to Frankfurter, and not
Okay.
merely to walk through. We can, of course, but we won't be able to read the book, right? Sometimes we go deep into
Right,
points from the
right,
book, but if
right.
we have a chance to leap from there to modern stuff, not for the sake of it being modern, but for the sake of it being a window to discussions that are happening
Yeah.
now,
Yeah.
and as a teaser, because we want people to buy the book. It's a number of other things. So the first thing we've been dealing with is, what is the Frankfurter era, and what is your expertise there? How does that inform our current understanding of the judiciary? And your point is essentially that that Frankfurter, who was viewed maybe as a turncoat, was actually manifesting judicial humility, and he thought the judicial humility was in fact not only the right thing to do morally, but the right thing to do strategically if one were trying to strengthen a sort of pro-social democracy. Right? That's how I sort of take your point.
Totally right. Wait, well, let me stop you right there. That was
Please.
part of it. But he saw judicial restraint, just to reformulate your idea, as a liberal constitutional theory, right? That if we left the elected branches, the states, Congress, and the Senate and the presidency to their own devices, by and large, with one big exception, and that's race in the 14th Amendment. But except for race in the 14th Amendment, he said if we left the elected branches alone, then we would have more liberal results than not. And he was thinking about things like minimum wage laws, maximum hour laws, things he fought for hard in the teens and the 20s, right? The right to unionize, right? These were, the right not to sign yellow dog contracts, forbidding unionization as conditions of employment. These were the things that Frankfurter worked really hard for legislatively, both at the state level and the federal level, once FDR got into power. And he said, look, you leave these elected branches to their own devices and they'll look out for working people. But if you let the Supreme Court just wield the Constitution like an anti-regulatory axe, right, that's just going to lead to conservative results. So judicial restraint is a liberal constitutional theory. And Frankfurter's, I think what he deserves credit for, and what I said he deserved credit for in the book, was he adapted the judicial restraint of his heroes, Holmes and Brandeis, neither of whom was really great on race, and say, wait a minute here, it can't be judicial restraint all the way down. We have a group of people in this country who are totally disenfranchised, and that's Black people in the South, and we need to enforce their 14th Amendment rights because they're unable to have a voice in our government. And so that's why Frankfurter was at the forefront of the move toward Brown versus Board of Education from the 40s on. It's why he hired the first African-American law clerk, William T. Coleman, who graduated first in his class at Harvard Law School and became Ford's Treasury Secretary, right? So, this is Frankfurter's move, right? Judicial restraint is a liberal constitutional theory, but adapting it to protect the rights of racial minorities.
And Frankfurter also, of course, had Lochner in his immediate rearview mirror, right? This was not something that, it was even weird when we first heard it. Certainly when I first heard in law school, what are we even talking about? Why even call it like this case? It wasn't anywhere in my awareness. It had not been covered in high school or even college, social studies as a public school kid for me. And of course, to the people in law school, it was like, oh yeah, this is, everybody knows what we're talking about. For him, he definitely knew what they were talking about, right? He had lived through that, and for him, sort of wielding of judicial power, the most important examples during his earlier life, during his, at the point you make, the story you tell, is during his life in law school. That's the freaking problem, is justices acting like kings. They weren't doing that to benefit Black people. They weren't doing that to benefit women. They weren't doing it because the majoritarian elements of the racist South were too much wielding power in the United States. They were doing it to make sure that oligarchs could stay oligarchs. They were doing it to make sure that the arc of history didn't bend anywhere.
You're totally right. It was this anti-regulatory Supreme Court of the United States. Lochner versus New York, which struck down a maximum hour law for bakers, that came down during his second year at Harvard Law School, right? That's like Bush v. Gore for you or I, Jeff, right? Which came
or
down,
Dobbs for I would say kids,
for people
in law
today,
school right now.
for Dobbs for law students today. It was his worldview that the Supreme Court was anti-labor and pro-business and anti any kind of regulation that might favor working men and women.
Another big theme of not just theme, heck, it's in the title of the Frankfurter legacy is not merely his legacy as a justice who votes or who writes, but as a leader, as a connector, as a relationship wielder, as a movement builder, as an establishment former, that he spent a significant portion of his life kind of building up, identifying his role as lifting people up, whether it was the treasury official that you mentioned, whether it was who was a top law student and one of the early black, did you say the very first black graduate?
So Frankfurter mentored the first black Harvard Law Review editor, Charles Hamilton Houston, the second black Harvard Law Review editor, William Hastie, and then the third black Harvard Law Review editor was William T. Coleman, and he hired him as a law clerk when he was on the court. But Jeff, you'll love this, right? Frankfurter's message, he was a professor at Harvard Law School for 25 years before he joined the court. His message to these Harvard law students, he would have loved you, by the way. He said, don't go to a New York law firm. Don't go to a Washington law firm. Don't go to a Chicago law firm. The highest thing you can do is serve the government, is public service. And so he's grabbing the arms physically, literally, to these Harvard Law Review editors. He's like, don't go work at Covington and Burling in Washington. Don't go work for Cravath in New York. Go work for Justice Holmes next year as a law clerk. Go work for Justice Brandeis. And then after you're done, go work in the Wilson administration, or go work in, the Hoover administration. He didn't matter Democratic or Republican. He wanted the best legal minds of their generations in government. And he preached that message for so long. He preached the same message to his law clerks. He had a former student or a law clerk in every presidential administration, from Taft, Wilson to Jimmy Carter, right? That's incredible, right? And that message of public service is incredible, right? He had scores of former students and clerks in the Kennedy administration. His best friend and former student was Dean Acheson, Truman's Secretary of State, right? Like, these were his people, and it weren't just white people. It was, Houston and Hastie, who was the first black federal judge in the United States, right? That's Frankfurter's former student, right? So it was kind of great. I mean, it wasn't unfortunately, it didn't include women, because sadly, Harvard Law School didn't admit women, right, for a really, really long time. And Frankfurter would have been a better judge had he taught women. Sorry about that, Jeff. Frankfurter would have been a better judge had he taught women. And there were a few decisions I would have liked to have had back. He famously turned RBG down for a clerkship near the end of his time on the bench. Harvard law professor came to him, Henry Hart, said, hey, you should hire this woman. She's transferred to Columbia for her third year, but she has a really good record, but I leave it up to you. And Frankfurter said no. And he gave a bunch of phony baloney reasons why he said no.
What were phony baloney reasons?
Well, he had a heart attack a few years before.
Yeah.
And Henry Hart had explained in the letter, which I have. I showed it to RBG when she was alive, by the way, Jeff. I had an audience with her in chambers, and I said, have you ever seen this letter from Henry Hart? She said no. And she read it. And, she was like the king of uncomfortable silences, right? She didn't say a lot of words like you or I do. She just paused and she sat there. And I said, well, what do you think? She said, typical white male chauvinism. But the reason was, one of the things, and this is true, so Frankfurter just had a serious heart attack. He was in the hospital for a while, and his doctor said to simplify his life. At the time, Ruth Bader Ginsburg's husband, Martin, had testicular cancer, and they had a young child. And he said, and Frankfurter's response to Hart was, I can't have a woman with a husband at home dying of cancer and a young child. I just can't have that additional stress in my life. My doctor told me to eliminate stress, and that stress I don't need. And now Ginsburg's response was, that's such a cop-out, and it was. Yeah. It was even worse what he told his law clerks, because I interviewed his law clerks. One of them, who's still alive, the former dean of Arizona State, he said to me, I curse too much. And the judge and the clerks go, "You don't curse, judge." And he said, "Well, I work you guys too hard." And they're like, "We're the least worst worked clerks at the court." He was trying to give all these phony baloney reasons why not to hire Ruth Bader Ginsburg. And it was a huge loss for him. Imagine what ideas she could have brought into his chambers. He could have been on the forefront of using the Equal Protection Clause to enforce women's rights. The Warren Court is notably terrible about this. Justin Driver of Yale Law School wrote an article called "The Constitutional Conservatism of the Warren Court," and Exhibit A for them is the Warren Court's rulings on women's rights. It was just terrible. Imagine if Ruth Ginsburg had been clerking on the 1959 term Warren Court, pushing to enforce the 14th Amendment to protect the rights of women. It would have been amazing.
And impacting that whole culture, right?
Right,
just
totally.
her relationships, impacting the worldviews of the other clerks and the other justices.
No doubt. Just as I benefited from clerking with you, Jeff, right, on the Ninth Circuit, right? It was fun, right? And you learned as much from your co-clerks as you did from your own judge and from clerks in other chambers. That's one of the beauties in being in a courthouse with a lot of really smart people. I thought that was, one of the great experiences of my life doing that.
Likewise. And to people listening, Brad was probably the best of us, or certainly one of them.
No.
So my, I want to get back to this sort of establishment building. And the first, because I was going to a question that I hadn't earned yet. And my question was, why isn't that happening as much? But I could be wrong, right? And it also could be, oh no, it was just because Frankfurter was kind of anomalous, and he was kind of one of one. But as a law student, I wasn't getting grabbed by the arm and saying, "Go serve," right? There was a little bit of still of a culture, and that was a good thing to do among other students. And there were professors that would, of course, been in favor of it. And there was absolutely the public interest law, like wing of the public interest law kind of organization within the school. So that absolutely existed. But in terms of influential professors themselves, right, I didn't feel, and I had Larry Tribe, right, and I didn't have a sense from him of like, hey, don't go take a job with Wachtell. Instead, you should go to do this, right, because you're made for more important stuff. And it did feel that the dominant pressure was to do the most prestigious thing. The definition of the most prestigious thing was the highest paying thing, and the highest paying thing sure as heck wasn't government work. So the first, do I have but that's again, just my experience, right? And I recognize that the experience of a white male in our era is different than the experience of a white male 50 years prior, right? It's different in some good ways. I don't necessarily mean personally beneficial, but like culturally beneficial. But before I just make that assumption, is it your sense that that kind of commitment by a law professor is happening less, or is it just that he was anomalous? And then I'll go into if it's less, why do we think so? But yeah, I think you see where I'm getting at.
No, totally. Well, first of all, I think like Frankfurter was like a one-man federal society on the left. Yeah. Right, creating these networks, right, of law, turning law students into public servants, and then networking with them. He was writing 15 to 20 letters a day. Today he'd be on Twitter, he'd be on Instagram, right, he'd be on podcasts, right, like we are, and he just created this network of liberal government lawyers on the left. And I just think after the New Deal and maybe after the Great Society, the left got like a little complacent about maintaining these networks, and the Federalist Society worked to its credit, starting in that early 80 period, really worked hard at creating networks, and the left then is now kind of playing catch up with the American Constitution Society and in creating these networks and encouraging lawyers to do things other than to go to law firms. The other thing I'd just say, Jeff, is the world was smaller then. And it was easier for Frankfurter to pick up the phone, right?
Yeah.
I mean, at one time, Jeff, Frankfurter was choosing law clerks for Holmes, Brandeis, Cardozo, Augustus Hand, Learned Hand, and at least one or two other judges, right? I mean,
and when you say selecting, what do you mean?
Carte blanche power. The judges, there was no interview. Whoever Frankfurter selected, the judge picked. Right. But if you think about that, that's how he was able to create this network, right?
Yeah.
That's where he's able to send someone like Alex. I mean, he's able to send just amazing people. He sent Dean Acheson for 2 years to clerk for Louis Brandeis, right? That's amazing, right? He sees potential in people, and then he basically assigns them a mentor for life, right? In a Holmes or Brandeis or Cardozo, right? Depending on their personality and their worldview, right? Tom Corcoran went to Oliver Wendell Holmes, right? And just I could go on and on and on about all the people that he sent to these judges. Joseph Rao is a great left-wing activist, went to Cardozo, right? So this is how he's able to sort of start the network, right? It's just the world's smaller, right? You don't have law professors with that type of power anymore.
Right. So lessons for now, kind of similarly as we were talking about with his jurisprudence, right? What are lessons for now? Is the American Constitution Society and Federal Society the lesson? It's like, young law students, are precious resources, and they should be recruited and directed to do things that are, in alignment with things that a movement thinks are good for that movement or good for the world, or is there more, or is there different?
I think it's even simpler. We want smart people in government, right? So it's just on me as a law professor that how Felix Frankfurter's inspired me as a law professor is when I see a really talented student, I want to encourage them to do something to serve our country, right? Whether that's maybe it starts with going to work for a federal judge, but then maybe it's going to work in the Senate for the Senate Judiciary Committee, or on some other Senate committee, or maybe it's going and working in the Justice Department, defending federal laws all over the country, right? In some place like government programs or the Civil Appellate Division, right? Just trying to sort of show them opportunities, or going to an agency like the FCC, where all the telecom stuff is happening, or the FTC to block mergers that are anti-competitive, right? So I just think if you see talented students and you figure out what they're interested in, and then you try to channel them in a direction that isn't just a cog in the machine of some big law firm, and that there's all these great experiences to be gained from the government, but also the government can benefit from having a person as smart as you are in it.
So back to Frankfurter himself, we talked about an establishment builder. We talked to him about his sort of judicial philosophy. Let's go even before that, because that's some of what I think makes your story a good story, right? Is that it actually tells the story of an interesting human being, and is a window to understanding a piece of American history. And it's a piece of American history that Fox News doesn't cite to very much, and everybody else kind of forgotten a little bit, which was a time when, let me say this, a little bit of an aside. I remember when COVID funding was distributed, and it even woke me up a little bit, because our entire life, and as a lawmaker for myself, as a voter, most of my life has been about constrained government power, about the reduction in the ability or the low level of faith in the ability of government to solve problems. And as somebody who used to have to pass budgets or vote on budgets, there was always, well, we're not going to afford this because we got a budget constraint. We're going to have to cut this, we're going to cut that. This has been the reality since the Carter era, right? Since Ronald Reagan was president. And all of a sudden, and this was under Donald Trump, you had COVID, and you have this huge unleashing of federal resource that props up the American economy, keeps us from going into a depression, right? Continues even to this day with every nattering nabob saying, well, we're gonna have a recession, 2 years ago. Well, it hasn't quite happened yet. And it even reminded me, oh, wait a minute, government can still do stuff, right? You have the affordable connectivity program that is getting low-income people access to nearly free telecommunications so that they can access that. Oh, wait, government can still do this stuff. In his life, even before being on the Supreme Court, was sort of the early days of, this isn't Bill Clinton saying the era of big government is over. This is the era of saying, wait a minute, we have a collective thing here that can solve problems. If we do stuff, we can maybe solve some problems together. And so I find your story interesting as a window into that. But why don't you tell some of that story? What were some of the things in your research that either reminded you of stuff you always thought was important, or like woke you up, or gave you perspective on something that was important you hadn't even noticed before?
Yeah, I mean, first, Jeff, like I think he had a tremendous amount of faith in state governments to solve problems, and I think the Democrats, as my friend David Pepper talks about Ohio all the time. He'd be a great guest for you, by the way. You have
He's been
former
one.
Ohio chair that he was on.
Yeah. David Pepper, also a friend. So David Pepper was on the city council in Cincinnati. And I met him when I was living at John Cranley's parents' house, when John Cranley was a law school classmate of mine, was running then for Congress, lost, ended up becoming eventually mayor of Cincinnati. And I met David Pepper and liked him very much. And
well,
in fact,
and like David Pepper and like John Cranley, like Frankfurter believed in state and local governments, and he believed that the states they were kind of locked out of the presidency for a long time and didn't really have the kind of White House that they wanted that was going to pass pro-labor legislation. He was kind of lukewarm on Wilson, and so when Brandeis joins the courts, he hands off his Supreme Court cases to Frankfurter. And that, I think this history, Jeff. It's Frankfurter defending the state of Oregon's minimum wage and maximum hour laws, right? Bunting versus Oregon is Frankfurter arguing before the Supreme Court in 1916 and 1917. And then 6 years later, right, he's defending a DC minimum wage law for minimum women and children. It's a case called Atkins versus Children's Hospital. Frankfurter thinks he slayed Lochner in Bunting versus Oregon, right? That Lochner's been what lawyers would call as sub silentio overruled, right? In kind of a velvet hammer fashion, that Lochner was dead. Well, in Atkins versus Children's Hospital, Frankfurter loses 6-2, and the court strikes down the DC minimum wage law and says that liberty of contract is the rule and the constitutionality of state laws is the exception, right? And Frankfurter says, I'm done, right? He says, I'm done arguing before the Supreme Court of the United States. He becomes one of the Supreme Court's biggest critics. But instead of just getting discouraged, he's writing articles attacking the court in the New Republic, but he throws himself into federal electoral politics. And, he backs Robert La Follette in the 24 campaign. La Follette loses. Walter Lippmann's like, you threw your vote away. And he said, Walter, my focus is on 1944, not 1924. He backs Al Smith, the first Catholic candidate of a major political party in 28. Smith gets destroyed by Herbert Hoover. Walter Lippmann, who I hate, by the way, he's a terrible person, that says to Frankfurter, the Democratic Party's over, right? I'm done. And Frankfurter says, no, the Democratic Party is going to be the liberal party in this country, right? There were liberals and conservatives in both parties at the time. He says, and the leader of the Democratic Party is going to be the newly elected governor of New York, Franklin Roosevelt, who won Smith's home state when Al Smith, the former governor of New York, lost it, right, in 28. And so Frankfurter becomes Roosevelt's advisor as governor. And that's when Frankfurter sees state governments, when they have someone like Franklin Roosevelt, even during the Great Depression, can do great things with regard to workers' rights, criminal justice reform, hydroelectric power, right? These were all the types of issues Frankfurter was advising Governor Roosevelt on, and that just continued when Roosevelt became president. The only problem with my story, Jeff, is that Frankfurter didn't stop advising Roosevelt once he joined the Supreme Court of the United States, and he was crossing ethical lines like crazy in ways that he shouldn't have, and he should have never been sitting on. He basically installed the Secretary of War before Pearl Harbor, Henry Stimson, his longtime mentor, and then kept voting on all these War Department cases like Korematsu, like ex parte Kirin about Nazi saboteurs. He should have never been sitting on Japanese internment and Nazi saboteurs cases. He was advising the War Department at the same time he was sitting on the cases. It was insane. Today, he'd be impeached in a hot second. So, that's the bad part of the story. But like I told it, and I criticized him for it. It was crazy.
Yeah. And one of the things that makes your story compelling, because it also gives you a window on how government was working in those days, right? And in part, it's even related to the thing you were saying before. It was kind of a smaller world. Picking up the phone and calling somebody to make something happen, that's kind of stuff that happened. And in fact, Frankfurter helped build the momentum for a structure of processes where that kind of thing wasn't the way to do it anymore, right?
Right.
And even what we're seeing now with a rise in oligarchic power is sort of, oh yeah, if you avoid government structures, if you avoid public structures, if you just do things based on handshakes and wealth, and then Donald Trump is your president, Elon Musk is your high priest, then yeah, you can avoid things like due process, etc. If we were clickbait artists, which either means if I were doing a different job or maybe if I were better at my job, we might highlight this, we might headline this as the most dangerous man in America. Because according to you, and not just you, but J. Edgar Hoover called Felix Frankfurter apparently the most dangerous man in America. And I just think it's fascinating, and maybe that should be our title for this episode. Why did J. Edgar Hoover name Frankfurter that? And how did Frankfurter, and this is before he was the Supreme Court justice, I think. So how did he end up as Supreme Court justice if the head of the FBI thought he was really dangerous?
It's unbelievable that you highlighted that. So after the Palmer raids, which is after World War I, Woodrow Wilson's Attorney General, A. Mitchell Palmer, said, I'm going to round up all the radicals and anarchists in this country. I don't care if I violate their due process rights. I don't care if we violate their Fourth Amendment rights to illegal search and seizure. I'm just going to lock them up and deport them all. And Frankfurter was asked by a federal judge, and the architect of those Palmer raids was a young Justice Department official named J. Edgar Hoover. So those raids were largely carried out by Hoover. And Frankfurter and another Harvard law professor, Zachariah Chafee, who became a huge First Amendment advocate, were asked by a federal judge in Boston to represent about 23 radicals, immigrants who were rounded up and scheduled for deportation in federal court. And they basically investigated the you-know-what out of the way the Palmer raids were conducted and found all sorts of unconstitutional conduct. And then there was a big report that a bunch of people signed on to accusing the Attorney General and J. Edgar Hoover of violating the U.S. Constitution. And Palmer called them liars and challenged them to a debate. And Chafee and Frankfurter said, I'll see you under oath before the U.S. Congress. Of course, Palmer didn't show. And then J. Edgar Hoover began opening up a secret file on Frankfurter in 1920 after all this stuff came out. But it gets worse. 4 years later, after the Harding administration, there's a ton of corruption in the Justice Department. Harlan Fiske Stone is made Calvin Coolidge's Attorney General. And Harlan Fiske Stone's job is to clean house in the Justice Department. Frankfurter sends Stone a letter and says, here are all the people you need to fire from the Justice Department. And Stone takes every single recommendation except one. He keeps this guy on who's the head of the Bureau of Investigation, and his name is J. Edgar Hoover. And Frankfurter says, what are you doing keeping J. Edgar Hoover in this position of power? And Stone's like, he will do all the liberal things I want him to do. And Frankfurter says, what about when you're no longer Attorney General? Then what happens with J. Edgar Hoover? And that's how Frankfurter essentially created an enemy for life in Hoover. He hated J. Edgar Hoover, and it goes all the way through, right? Even though they reached a kind of detente publicly, right? Frankfurter always used to say, oh, so-and-so is just a stooge of J. Edgar Hoover. He couldn't stand him. And so
how did he get through? How did he get approved? How did he get confirmed with J. Edgar Hoover as enemy? Maybe it's a limit to J. Edgar Hoover's power.
Yeah, I don't think Hoover could take on Roosevelt on this. But really, it's funny you ask. Frankfurter's the first nominee who's ever compelled to testify before the Supreme Court of the United States in order to get confirmed. And there's an anti-immigrant, anti-communist, Pat McCarran from Nevada. He's like Joe McCarthy before Joe McCarthy, and he grills Frankfurter. And there's all these crazy people who testify accusing Frankfurter of being a communist when he's anything but. By the mere fact that he's a Jew who's influential in the Roosevelt administration. So, he got through. By the way, Jeff, they didn't have a roll call vote when Frankfurter got confirmed. It was a voice vote. It's one of the last times they said all in favor say aye and all in favor say no. And they recorded no votes when he got confirmed because people didn't want to go on the record for or against. That's how he got confirmed.
Interesting. All right. So a little bit more on as we go into sort of the history. So his, as we think about the development of American law and kind of the strains, those are strains of human of ideas, and are taught as strains mostly of ideas and the laws. We now know more than ever that they are also strains of applications of power, be they lagging indicators or otherwise, right? It's not just like the best idea wins. It's who is in the position of power, because they build the establishment, build the organization, build the network, et cetera. They get elected, they appoint the people that are able to make the decision, whatever. Okay. And then there are also the strains of human beings, right? The unbroken chain, the person who hands off the baton of an idea, or the person who doesn't even hand it off, but somebody goes and, picks their book off the shelf and says, I want to do it like this person. And Frankfurter had an idol, and that was Oliver Wendell Holmes, as I understand it. In what ways was Oliver Wendell Holmes an idol, and in what ways was that helpful or maybe problematic?
Yeah, I mean, I think Idol's strong. Like, so to me, it's Roosevelt, right? So I think when Frankfurter was young, he was captivated by Holmes, because Holmes was someone you would want to have a beer with. He could talk about any subject. He could disagree with you without being disagreeable, but he was open to young people's ideas. So when Frankfurter was a young person who came to Washington, and he's able, because DC is so small in 1912, to have Oliver Wendell Holmes over for dinner. He's the guy, and not Brandeis, even though they have Brandeis over for dinner, and Brandeis is the progressive and Holmes is kind of the skeptic, right? And, they love Holmes, right? Even though they agree with Brandeis. And don't forget, Jeff, we talked about Lochner before, Frankfurter revered Holmes's Lochner dissent, which basically accused the conservative justices of the Supreme Court of reading their oligarchic economic ideas into the Constitution, right? So he's already a hero from way back in 1905. And then you find out your hero is a great guy and a great conversationalist who's open to your ideas, right? And willing to uphold all of your pro-labor legislation, not because he agrees with it, but because he doesn't think the justices should interfere, right? And then he happens to be the best writer in the court's history. Maybe him and Robert Jackson are the best writers ever on the court, right? So it's a mix of things, but it's also just a close affinity. He was so close to Holmes on a personal level, but in terms of elected officials, it's FDR, right? Frankfurter saw FDR as the greatest American president besides Abraham Lincoln. And he knew that as early as 33 or 34. He saw in FDR the ability to be one of the greatest presidents in our history, and to invest. And FDR was willing to listen to experts, right? And to have an expert-run government, right? And to trust people with subject matter expertise. And Frankfurter really admired that. He knew that FDR wasn't a genius the way that Holmes was a genius in the way he could write, but he saw that FDR could be a highly effective president. And he was.
Something I hadn't caught until we were doing prep. They're born in the same year.
Wow, 1883, right?
1882. So FDR right at the very beginning, January of 1882, Frankfurt at the very end of 1882.
November. Yeah, November 15th, 1882. You're totally right.
So they're contemporaries, and I hadn't thought about that before. All these people seem ageless to me, right? So they're all just the picture.
And of course, Jeff, they crossed paths in World War I, right? FDR's assistant secretary of the Navy under Wilson. Frankfurter's the chair of something called the War Labor Policies Board that's trying to standardize employment practices throughout the federal government and federal industry, and war-related industries, with maximum hours and minimum wage laws and those kind of things. And FDR is on that, a representative on that War Labor Policy Board. He brings Frankfurter home for lunch one day, and Eleanor, this is, of course, like 1917 or 1918. She writes in a letter to her mother-in-law, an interesting little man, but very Jew. That's what she writes about him. And so, he ends up becoming great friends with both Eleanor and Franklin, and stays at the White House on the regular in the 30s before he joins the court. But they will go way back, right, is my point, right? They'd been through all of the big battles against, big business, going back into the teens. So he knew, he saw the greatness in FDR, particularly when he became governor of New York.
What was his view? And I think about this and the attack on from even pre-Nixon, but certainly Nixon, and then maybe more popularized and more of as a battle cry in the 80s and after, was sort of the liberal elite. But this is kind of what we're talking about, right? A group of people who weren't the economic elite, weren't the most powerful people, but then worked in part. I mean, FDR was born rich, but a lot of these guys weren't born rich, but worked hard to figure out how can we solve problems publicly. And then they get derided and marginalized and say, oh no, this is a liberal elite. This is why poor people, some of you all ought to be voting for oligarchic politics, because these people are actually in power. And I sort of think about the liberal elite every time we hear about the relationships between, as you sort of at Harvard, and they say, okay, we're here, we're at this fancy school. Let's go get some people, some other smart people to go do some stuff that's good for people. And they get derided for the liberal elite. And I just find it interesting. Brandeis, what was his view towards Brandeis?
He loved him, like he eulogized him, right? It was the people who eulogized Frankfurter at his funeral were Felix Frankfurter and Dean Acheson were the two people at eulogizing him, but they had a complicated relationship.
Eulogized Brandeis.
They were the ones eulogizing Brandeis at his funeral. I think it was in 1943, but it may be 41. I can't remember on my dates. But Frankfurter's relationship with Brandeis was a little complicated. They were both progressive in the sense they were pro-labor, they were anti-big business, they had some different views economically. What complicated their relationship is Brandeis was a multimillionaire. He'd been a big-time lawyer in Boston. He had all these pro bono things he wanted done, and he was paying Frankfurter to do them. And those payments lasted while Brandeis was on the court and
Wow.
Frankfurter was a private lawyer. Where they broke, Jeff, and almost stopped being friends was over court packing, because Brandeis was furious with FDR's efforts to try to increase the number of justices on the court. And Frankfurter had pledged to FDR to remain neutral during court packing. And he was also mad at Brandeis for signing a letter of Senator Wheeler's that effectively killed the court packing plan. So they were really mad at each other. And they needed a third party, another federal judge they were friends with, a guy named Julian Mack, had to basically act as an intermediary so they could stay friends after court packing. And part of me thinks, Brandeis retired a week after Frankfurter got on the bench because he was mad there were liberals in the New Deal like Tom Corcoran and Ben Cohen who were trying to push Brandeis to retire, right? Kind of like liberals were pushing, Ruth Bader Ginsburg and Stephen Breyer to retire, to make way for Frankfurter, and Brandeis wouldn't do it. And so he refused to get off so Frankfurter could get on the court. And so, I think their relationship was a little strained post 1937. They were still really close, but the wars that they'd been through together about minimum wage laws and maximum hour laws, that kind of stopped. I think Brandeis thought Frankfurter was too close to FDR and too loyal to FDR. And that's true. I think Brandeis was right. But I think Frankfurter's also right that Brandeis shouldn't have weighed in on the court packing plan.
The focus of the book, of this portion of the discussion, obviously been on Felix Frankfurter. But when we do these discussions, we're also sort of interested in the author, right? And I imagine you writing this, coming in with certain motivations for why you wanted to, things you already knew, hypotheses you were testing. And so I am interested if there's anything that surprised you, but I'm also interested in the impact this process had on you, how you think about your role as a law professor, as you think about your law students' roles in the world and how they might approach the world, as you think about, if you've got another, 30 to 50 years of productive activity, how does it impact your thinking about how you want to be you?
Yeah, I mean, Jeff, I went to a different law school than you did, and the law school I went to put the Warren Court on a pedestal. And some of my most brilliant professors, had clerked on the Warren Court and just, told you stories about Justice Brennan and Justice Marshall and Justice Harlan and all the great Warren Court justices. So I just had this kind of the court on a pedestal from law school, and then Bush v. Gore happened, Jeff, in 2000, and when they short-circuited Florida's recount in the 2000 presidential election, and my kind of worldview of the Supreme Court was shattered. And I had to start rethinking what I wanted the role of the Supreme Court to be in our democracy. And so I think this book really helped me rethink the role of the Supreme Court in our democracy. And it helped me realize that the Warren Court did some wonderful things, like Brown versus Board of Education, like just fighting for racial justice when before 1964, no other branches of government were really fighting for it, right? And I give the Warren Court a ton of credit for that, but they also did a lot of really bad things, like this idea of judicial supremacy, this idea of the Supreme Court is the ultimate constitutional interpreter. I see that as a negative legacy of the Warren Court. So I see the Warren Court's legacy now as a result of this book as kind of a mixed bag. The racial justice stuff was great, right? Creating a kind of all-powerful Supreme Court was not so great, right? So I think that's what the book really taught me, and it's changed the way I teach constitutional law to my students. It's kind of less court-centric, and I do try to show my students that the other branches of government play a co-equal role in interpreting the Constitution and are equally powerful, and that we should be using that power under our constitutional system. So that's what I think the book taught me. And I think Frankfurter had a faith in democracy in our institutions other than the Supreme Court of the United States. That really helped me it restored my faith in those institutions. And then just the way that he mentored his law students and his law clerks tried to make me a better mentor to my students at Georgetown and help them, show them that there's a different path than just spending 5, 10, 15, 20 years at a big corporate law firm, and that there are more important things in life than just making a lot of money, and that one of the greatest things you can possibly do is serve your country in the federal or state government.
Wonderful. To amplify and maybe add one thing, the faith in democracy, the commitment to building institutions, to building public structures. Something else you said earlier was that the big D democratic power was maybe tactical, but not strategic. What occurred to me from this conversation, something I've learned in this conversation, was even this idea of judicial restraint. Like during our formative years, that was a rhetorical cudgel used to go after Roe versus Wade, used to go after what they would call liberal judicial overreach. So when you and I were being raised, that argument seemed like a Republican argument. That argument seemed like an argument it was like saying states' rights. You can say states' rights, and what you actually mean is, let's make sure you can do feed-in tariffs so that local people actually have a chance to make money if they put a solar panel on their house, rather than just deferring it all to some private electricity company. You can have states' rights and local rights, et cetera, that don't just mean or mean precisely different than be racist. But this idea of judicial restraint, I mean, it seemed like a dog whistle for bad stuff. And so what this has helped me do is realize, oh, wait a minute. Very often we can confuse the argument for a principle. That the rhetorical flourish, the persuasive point, in order to build power, in order to undercut the liberal thing, in order to build the fundament that becomes Fox News, et cetera, that we say judicial restraint, but that argument is different than the principle. And from you, it's like, there's actually a real good point to judicial restraint. There's a real good point to a humble Supreme Court. There's that the Warren Court was an anomalous. The Warren Court was an outlier in the story of the Supreme Court. And so, yes, most Yale law professors grew up with that legend. And so they teach that legend, wait a minute, let's not be gnats where we're born in winter and we think the whole world has been cold. That's in fact, understand the onward sweep of history, which another reason why I really appreciate your book as a window of history, or using history as a window to understand what we're up against now.
Well, I really appreciate that. What's really gratifying to me is to see all these really bright young law professors, younger than I am and younger than you are, who are really developing this history of judicial restraint. You've got Daphne Reinen and Nico Bowie at Harvard Law School writing a book about Supreme Court overreach during the 19th century and are really in favor of judicial restraint. You've got Ryan Dorfler at Harvard Law School, who believe in judicial restraint as a liberal constitutional idea. You've got Sam Moyn at Yale, same thing, writing about James Bradley Thayer of Harvard Law School, who had it right all along, right, about judicial restraint. And so it's interesting to me that the next generation of constitutional thinkers is viewing the Warren Court just the way you described it, as a fluke, as an aberration. And by taking a longer view of our history, you can see the kind of conservative or even reactionary role the court has played in our history, and that we need to look to other institutions to solve our problems. That was Frankfurter's lesson all along. We just forgot about it because we were winning Supreme Court cases.
And as I think about it, it should have occurred to me a bit ago. But what almost anybody would want is restraint by the people we disagree with. And activism is what we agree with. But your point is that if you build institutional constraint, if you build institutional restraint, then you can sort of right size the power of that institution. It could be more appropriate. If it is in fact a lagging indicator, it could be more appropriate and fulfill its constitutional role more appropriately.
Right. And I just think also Democrats need to invest in other institutions, right? And just as hard as they sometimes, gnash their teeth about Supreme Court opinions, that they should be, lobbying their representatives both in Congress and at the White House and at their state houses, right? And so I just think, we need to invest in our institutions. And I think that's what Frankfurter did, was he invested in state governments and state legislation, and he invested, his mind, body, and soul in federal legislation and federal government, and didn't wait for the Supreme Court to come around to his ideas.
Well, Brad Snyder, law professor, Georgetown University, author of the book Democratic Justice, Felix Frankfurter, the Supreme Court and the Making of the Liberal Establishment. This has been a treat for me, man. It's been so great to catch up. I'm glad we've had a chance to do this, and I can't tell you how much I appreciate it.
Likewise, I forgot how great you are and how smart you are and charismatic you are, and it just brings back a lot of great memories. And I hope this isn't the last time we talk.
All right, man. Be well.
All right, take care.
Cheers.